Section 3. Patentability. This is about the statutory requirements for granting of patents. The patentability tests are the most fundamental requirements or principles under patent law to serve the very purpose of the patent system, striking a well-balanced system to guarantee the interests of individual patent owners and the interests of the public for disseminating technology and new ideas. In different countries, the lawmakers may pick up different wording to formulate these principles. However, generally speaking, patent law universally would require that in order for an invention to be patentable, it must be novel. It must be new, different from existing technologies. Number 2. The invention must be non-obvious. This is called non-obviousness test, the term used in the US patent law, or involve an inventive step, the expression used in European patent law. It may also be called inventiveness requirements. Number 3. The US law requires that the invention must be useful or be capable of industrial application, as the term used in European patent law. As we said earlier, these lawmakers pick up different terms, different wording to formulate these principles, but generally speaking, it's about very similar rules. Number 1. Novelty test. An invention is new or novel if it does not form part of the prior art. So here, the term prior art would be very confusing to those who never came across patent law. If you still remember the very first modern patent legislation, or the first legislation which set forth a patent system in a modern sense, the UK Statutes of Monopolies 1623. It says there would be no patents anymore except those for those inventions invented in the future, which is truly new. So, to be patentable, the invention must be new. Well, how can you determine that this invention is new? Right? It's new or old. It's relatively judgment. You may say compared to the technology that we had yesterday, this technology is new. But compared to the technologies that might be disclosed tomorrow, next week, next month, this technology, this invention here might be old. You see, the invention is new or old is a comparative or is a relative issue. Well, actually, under modern copyright patent law, whether an invention is new or not is quite clear. the principle, the rule to determine it is that compare to the prior art, this invention does not belong to any prior art or does not fall within the scope of any existing technology. So what is a prior art? Here, prior art as a very specific term used in patent law refers to all relevant technical knowledge available to the public anywhere in the world prior to the first filing date of the relevant patent application. What does it mean? Number one, whether it's novel or not is to be determined based on the comparison between this invention and any technical knowledge, any technology available to mankind, known to the public in any country. So this is an universal novelty requirement. This invention is new in this country. It's never been disclosed in this country, never been used in this country, but it might be available to the public already in another country, in Africa. Well, if that's true, then this invention will not satisfy the novelty requirements. This is called in universal novelty requirements. But years ago, national legislation may only require national novelty. It means if this technology is new in this country, that would be regarded as a novel invention. It would be sufficient enough to satisfy the patent requirements. But today, Chinese patent law has been following the so-called universal novelty requirements. Number two, whether the technology, this invention is new or not, is compared to the technology which being available to the public before the date of filing. So here, the date of filing will be very critical to establish the scope of a prior art to the inventor, right? For instance, if today is the date of filing, you see any existing technology, any information being disclosed to the public would fall within or disclosed before today, as tomorrow, that's yesterday, will be considered as prior art. However, those technology, those information disclosed tomorrow, the day after tomorrow, in the future, those technology, those information, those knowledge would not be considered as a body of prior art to this invention, to this application. Under Chinese law, you will see the Article 22 of Chinese patents provides that novelty means that the invention or utility module neither belongs to an existing technology, prior art, nor has any entity or individual previously filed before the date of filing with the Patent Administrative Department, the National IP Administration today. So before the date of filing, any knowledge available to mankind will be considered as part of a prior art, and any knowledge or technology being filed before by someone else with a patent office would also be excluded. Number 2, non-obviousness test. An invention is considered to be involved in, or considered to involve an inventive step or to be non-obvious when taking into account the prior art. The invention would not have been obvious to a person skilled in that particular field of technology. Basically, it means this invention must be advanced enough. The advancements between your invention and the existing technologies, this invention might be quite or quite inventive in a term, let's say, to be clarified by Chinese legislation as having prominent substantive features and represent a notable progress. That requirements apply to invention. To utility modules, the requirements is less restrict as the one applied to invention patents. To utility modules, it merely requires that the application has substantive features and represent a progress. You see the differences. To inventions, it's required that it must represent notable progress. However, to utility modules, it requires for a progress. So comparatively, the requirements of inventiveness of for utility module is less stronger than the requirements for invention patents. Number 3, the invention must be useful, or using a term under European law, it must be capable of industrial application. The Chinese law using the term practical applicability basically is talking about very similar requirements as a term used in European law. The invention or utility module can be made or used. It means the invention can be enabled. It means, well, you see that your invention, you can make a new device which is optional, functioning. You make it and let us see it. The mere proposition of a theory or a presumption is not enough. You cannot say, well, I think it should work. Well, it should work not enough. It must work. You must demonstrate a case. Show to the patent examiner that, well, it's working. It works as exactly as you claimed in your patent documents. And it can bring positive effects. It means it's not harmful. being useful. So put another way, the requirements of usefulness or capable of industrial application means number one, it must be made or used or applied or enabled. Number two, it must be useful or not harmful. There could be some technology that's just useless in the sense it cannot help mankind but to destroy mankind, or it might be against public morality, or jeopardizing public interest, or the public health. So, an invention cannot be a mere theoretical phenomenon. Cannot be a proposition that cannot be enabled. It must be useful and provide some practical benefits, generate some positive effects to the society. The patentability test applied to invention patents and utility modules are a little bit different from the patentability requirements applicable to design patents. Why is different? Simply because design is so different from technological innovation. It's not about technical solution to any technical problem. A design patents is merely to make the products looks nice. So Article 23 of Patent Law of China provides that for a design to be patentable, there's two requirements. Number one, the design is novel. Right? It's neither belongs to the prior design nor has any other person filed before. So it's a new design compared to prior design. The design available to the public before the date of filing. And then number two, the design being applied for patents, for design patents must be substantively different from the prior design or a combination of the feature of the prior design. Well, here you may say the requirements for design patents and the novelty and non-obviousness requirements for invention patents shares similar philosophy or similar purpose. That's to guarantee that the design is truly new, is worth protecting. Here, in the case of substantive difference between the design applied for patents and the prior design, European law uses a concept of the design for patent or for design rights or applying for registration of design rights must embrace or must owns individual character. Well, these requirements is a little bit higher. You see, compared to the Chinese definition or the wording used by Chinese lawmaker. The concept of individual character requires a higher degree of distinction between the patents, between the design applying for design rights to the prior rights, to the prior designs. The purpose of doing this is to enhance the quality of designs,